Permission. My lord.
The page number. Before we enter into this, we have noted that you have filed a section 17. So section 17 being more appropriate.
No, my lord, my submission is the DRT has no jurisdiction. What the issue here is, I am asserting certain rights and corresponding obligation on the banks and financial institutions in terms of the notification dated 29/5/2015 issued by the central government under section 9 of the MSMED Act. And the MSMED Act and the notification, insofar as has not provided any forum for enforcement of those rights and obligation, the civil court jurisdiction is not outset. I rely on the judgment of Dulabai 9-judge constitutional bench. Sorry, Mafatilal, 9-judge constitutional bench of the Supreme Court in the Mafatilal, and 5-judge constitutional bench in Dulabai. So the surface here comes at a later stage. The MSMED Act practically has, for all practical purposes, repealed the Surface Act insofar as MSMEs are concerned. Now that one of the prayer I sought, may I take your lordship to the prayer in the writ petition. My lord, I have sought a declaration. May I take your lordship to the prayer? Prayer in the writ petition. Prayer E at page 67. Prayer E at page 67. To declare that your lordship got at page, prayer E at page 67. May I read, my lord? Yep.
Yes.
To declare that, yes, prayer E, to declare that insofar as the MSMED Act and the notification dated 29/5/2015 creates certain obligations and burden as against the bank and certain rights and protection in favor of the MSME borrower in furtherance of the larger public interest, and has not provided any forum for the enforcement of the said inter-se rights and obligation, inter-se rights, adjudication of disputes, the civil court jurisdiction is not outstead. So therefore this issue has never been decided. My lord, I rely on the judgment of 9-judge constitutional bench in Mafatilal. In Mafatilal, the 9-judge constitutional bench has relied on, my lord, the 5-judge constitutional bench in Dulabai. So the fundamental principle is the civil court jurisdiction can be taken away, and provided that is invested in another forum, and without creating a forum in substitution of the civil court, the jurisdiction of the civil court cannot be outstead. So the notification dated 29/5/2015. The only mechanism for enforcement of the rights is a committee, and the person agreed by the decision of a committee is permitted to make an application for review before the committee. So supposing in a case as the instant one, no committee was ever constituted, then which is the forum which can enforce the rights under the Act? So the DRT is only a tribunal. A tribunal cannot even grant a declaratory relief. It's a fundamental principle. Unlike, there's a difference between a court and a tribunal. There's a difference between a subject and a body corporate. So a citizen like the king is free to do whatever is not expressly prohibited by law.
Yes, filed another petition.
No. Now the question is, the difference between a court and a tribunal is, a court is free to do whatever is not expressly prohibited. Supposing that the civil code has been expressly prohibited or by implication for going into the respective rights and obligation under the any dispute concerning the enforcement of the respective rights and obligation under this notification dated 29/5/2015, then the civil code jurisdiction is outside. So civil code is free to do whatever is not expressly prohibited. And section 9 of the CPC, civil court is a court of record of plenary jurisdiction, empowered, competent and duty bound to adjudicate anything under the sun of a civil nature. And that was the position, my lord. That was the position even prior to the coming into of the constitution. We had a constitutional enactment called the Government of India Act of 1935. In the Government of India Act, there is of 1935, there is a 7th schedule, and the 7th schedule is the very same 7th schedule of the Constitution of India. In the Government of India Act, there is a union list, state list, and the concurrent list. The federal list, provincial list, and concurrent list. In the Constitution, we have the union list, state list, and concurrent list. And the concept of ultra vires was very much available even during the Government of India Act. And there was no courts. The writ jurisdiction was not available except from the presidency towns of Bombay, Madras, and Calcutta. All, whereas constitutionality of a statutory instrument, statute or a statutory instrument was under challenge, then the only court which could have gone into is a civil court. So the civil court is a true court of plenary jurisdiction, empowered, competent, and duty bound to embark upon a civil any controversy of a civil nature under the sun. So that then unless there is a bar expressly or by even implication taking away the jurisdiction of the civil court, then I cannot be forced to, my lord, approach the DRT, and my lord, the DRT and my friend and me, we all together by consent cannot confer a jurisdiction on DRT where the statute has provided none. So this issue of the lack of jurisdiction on the part of the DRT to adjudicate interstate dispute between me and the banks and financial institutions in the enforcement of the matter of enforcement of the rights under the MSME Act has not been decided anywhere. And on the contrary, there are even with not involving MSME claim, in respect of ordinary surface claim also, the Supreme Court has held the jurisdiction of the civil court is not outside.
You have filed a review. Review is pending.
The review is pending before the committee, but my lord, all issue there is no committee.
No. The largest single judge.
Yes, my lord. RP number 384/26. Yes.
No, my lord.
Review RP number
384/26. Moreover, my lord, case filed another petition.
RP number 324 of 2026.
And these are this petition filed by the very same party, my lord. The relief is one and the same. The matter is posted to tomorrow before a single bench.
No, my lord, is it a case serial number, writ appeal number, I have written 649 of 2026, my lord. Is it the Srimada Cosmetic Industries?
Yes.
No. What your learned friend is saying.
Yes.
You have filed a review before the learned single judge. That is RP number 324 of 2026.
No,
You have also filed a petition before the learned single judge, praying injunction. Now that is with regard to constitution of any committee.
Yes, Miss.
No, my lord, the all issue, my lord, if I file a suit, I have to follow order on rule 1 of the CPC. All parties, all controversies has to be brought before that quorum. But when a repetition, my dear friend, let me answer.
Case number 67.
Yes.
Relief C, D, F and G, my lord. in the present writ petition, page 67. In the writ appeal, running page 67, my lord, in the writ appeal. Relief C, D,
And D.
F and G.
D.
F, D, C, D, F
This is also
and G.
challenged in the. This WPC number.
WPC number 26, the present new,
No, the new one.
new one, 26,775 bar 26. 775 bar 26.
26,775.
Yes, my lord. That was in fact posted on 7/8/26 and it is posted to tomorrow.
Which one?
Ma- ma-
No, my lord. The new writ petition is filed.
Yes. Now let me explain, my lord. Let me explain. If there is a residucator, there is a bar. If there is no residucator, there is no bar. Section 11 of the CPC, my lord, has codified the concept of the codification of the concept of residucator. Your lordship will find in section 11 of the CPC. So for residucator to apply, there must be a termination of lease. May I take your lordship to section 11 of the CPC? Section 11 of the CPC. Your lordship have section CPC, my lords?
Yes, we are aware of this. We are aware of this.
Yeah, my lord. Now the point I am canvassing is for the doctoral residucator to apply. For the doctoral residucator to apply, my lord, the issue must have been finally decided by such court. Read section 9. No court shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially issued in a formal suit between the same parties or between the parties under whom they or any one of them litigating under the same title in a court competent to try such subsequent suit, or the suit in which such issue has been subsequently raised and has been heard and finally decided by such court. There is no termination of lease in SARFAESI matters. There is a new cause of action. A new auction notice was issued. The SARFAESI Act, there is a fundamental defect. In Ashok Sawmill's case, the Supreme Court said, when every new cause of action will entail in a new right to institute a new proceedings. So there is, for the doctor residucator to apply, there must be a termination of lease. There must be a termination of lease, and the termination of the lease is a result of a final adjudication on merits, either actually or constructively. And my lord, the original cause of action, the concept of residucator, it comes from Ulpian. Your lordships may say in the Justinian's Digest, book number 42. Justinian's Digest, book number 42. The concept of residucator comes from that. In fact, all of our legal system, all of our jurisprudence come from Justinian's Digest. Very few lawyers and judges would have seen it. Justinian's Digest. And my lord, your lord Chief Justice may take your lordship.
Have you responded to the notice of section 13(2)? Have they responded to the notice under section 13(2)?
No, my lord, they have not responded. And that has
No,
been
my
made
lord,
clear in the
No, let me, your lordship may permit me to
that
say
has been
five
made very clear in the
No,
judgment.
my lord, let me present my case in a few words. I will take very little time. I may take your lordship to page 506. But let me point out a few facts.
Squarely,
No, a few facts on very few facts. My lord, very few facts. 5 minutes give your lordship may give me. Let me take your lordship to the facts. Because any discussion has to be based on facts. May I take your lordship to page 506. 506 of the writ petition. May I take your lordship, Honorable Chief Justice, may I draw your lordship's most gracious attention to page number 506 of the writ appeal. I will take very little time, very little facts. My friend may not interrupt me. Allow me 5 minutes. I conclude in 5 minutes. Yes, your lordships may take you. I may take your lordship to page number 506. Your lordship got my lord Chief Justice. My lord, your lordship got it. Your lordship got my lord. This is the UCO Bank. This is the renewal of credit facilities. It's a sanction letter at page 506. And the top of it, yeah, SME, small manufacturing. The very loan is a MSME loan. The very loan is an MSME loan. There is no question of I informing the bank. There is no question of the bank not being conscious of the fact that the borrower is an MSME, having proceeded to invoke classify the account as NPA, and proceeding to issue notice under section 13(2). I am an MSME. The loan itself is an MSME loan. The loan was obtained, sanctioned to me after obtaining all necessary documents, satisfying itself that I am an MSME. The loan is an MSME loan. And if there is if the loan is an MSME loan, the banks are under a duty to, my lord, identify incipient stress. Identify incipient stress, create SMA 0 account, consider a committee, make a reference to the committee, and the committee is a judicial tribunal. It has issued notice to all concerned. And if the committee comes to the conclusion that resolution of stress is not feasible, the committee is empowered to recover the money. This is a statutory scheme. It's a preventive legislation to prevent MSMEs from falling sick. It's a benevolent, it's a remedial legislation. If the MSMEs have fallen sick, to revive it, give it a new life. It's a benevolent legislation. It's a welfare legislation. Obviously it should receive a benevolent construction. But I am not asking for that. I am only asking for what is not the literal interpretation. First principle, a statute has understood in terms of the express words employed by the legislature. And the notification contemplates 6 stages. First stage is, my lord the Chief Justice, my lord, the first stage is where an MSME identifies incipient stress. When there are no signs of stress, my lord, I request your lordship, the Chief Justice, to lend your lordship's ears. Now, my lord,